What's going on YouTube? Listen up, young elder gang. This is Dr. Joe Blow at you with another banger. Please make sure you like, subscribe, and share this video, fam. I hope this video get at least 100,000 likes. In this video, you will find history, definitions, scripture information, and best of all, what we Americans have been deprived of from the beginning, the truth. Keep in mind, this content used in this video is intended for entertainment, educational, and informational purposes only. We will give you the total truth as we best understand it today. Be sure to hit that like button, young elder gang. Hit that subscribe button if you're new to the channel. Hit that bell and don't forget to check back with us every day for new content. This is part 2 of the letter to Obama from the Pope. If you haven't checked out part 1, be sure to check out part 1 just below this video on the video side. What is usurpations? Usurpation is the act of taking someone else's power, position, or property by force or without permission. For example, locking a teacher out of the classroom and taking over the class is a form of usurpation. Synonyms of usurpation include appropriation, arrogation, assumption, and seizure. The word usurpation comes from the Latin word usurpation, which means a seizing for use. In law, usurpations refers to the act of wrongfully seizing or taking control of someone else's position, office, power, or property without legal right, essentially meaning to take over something that is not rightfully yours, often by force or deception. It implies an illegal or unauthorized seizure of authority or possession. Usurpation is considered a legal violation, as it involves taking something without proper legal claim or permission. This term is often used in situations where someone tries to seize a position of power, like a leadership role, without proper authority. If someone were to take over a company's management without being appointed by the board of directors, this could be considered an act of usurpation. A more thorough explanation. Definition: usurpation is the act of taking someone else's position, office, or authority without permission or legal right. For example, if someone takes over a company without the owner's permission, that is an act of usurpation. In law, fraud is a criminal or civil act that involves deceit, dishonesty, or false representation with the intent to gain a personal or financial advantage. Fraud can include making false statements, withholding important information, faking documents, and concealing information. Fraud can be committed by individuals or organizations to obtain money, property, or services, avoid paying or losing services, secure a personal or business advantage. Fraud can be prosecuted as a criminal offense, or a victim can pursue a civil case. The potential punishment for criminal fraud varies by jurisdiction and the type of fraud. For example, in the federal system, the potential sentence for bank fraud is up to 30 years, while the potential sentence for healthcare fraud is up to 10 years. In civil litigation, allegations of fraud might be based on a misrepresentation of fact that was either intentional or negligent. For a statement to be an intentional misrepresentation, the person who made it must either have known the statement was false or been reckless as to its truth. Since the national emergency in banking, otherwise known as bankruptcy, occurred in 1933, our money is credit, your credit, backed by your collateral or your promise. When you sign any promise to pay, it becomes money. What is the difference between Federal Reserve notes and the promissory note you gave the bank? They both represent your credit. Only one thing is different. The bank failed to record your promissory note when they recorded the deed of trust. Therefore, it is not registered in the public register like FRNs are. Could this be considered fraudulent use of a foreign security? You better believe it is. Notice that the title of this video doesn't include the word "the." Just as General Motors doesn't imply a plural number of motors, United States does not imply a plural number of states. There is nothing plural about the contemporary use of the term. United States is a singular proper noun, and correct usage does not include the antecedent definite article. The United States is a corporate trade name like General Motors and identifies a corporation, albeit federal and municipal, but a corporation nevertheless. Just as proper English doesn't include the Canada, the Finland, or the Egypt, it likewise does not include the United States. A far more accurate indicator would be the state of United States. We read of the state of Great Britain in the Declaration of Independence and hear of the state of Israel in the news. The proper recital of the name United States identifies the for-profit, bankrupt commercial enterprise in Washington, D.C., presently managed by the receiver in bankruptcy, Secretary of the Treasury of Puerto Rico, aka Secretary of the Treasury. The United States is a slyly concocted fraud that plants in the mind the notion that its identity is merged with the states, when in fact it is foreign to the people-states. All parties must be brought to understand the nature of the federal government, the limitations of its authority, and their own obligation to act in favor of the organic states of the Union. The Grand Army of the Republic shall continue to operate under General Order 100, known as the Libra Code, extant from the pen of the last Republic President Abraham Lincoln. No orders, executive or otherwise, issued by Barack H. Obama, pretending authority on the land of the American states while operating as President of the United States Corporation, nor as the President of the United States of America Minor, are owed any performance by the Joint Chiefs, Staff, General Ham, or any ordinary. What is the nature of the federal government? A federal government is a system where power is divided between a central national government and individual state governments, with each level having defined areas of authority, essentially meaning that power is shared between the national government and regional entities within a country, like states in the United States. This is often referred to as federalism in political science. Key points about a federal government. Shared power. The central government and state governments each have distinct powers and responsibilities that are outlined in a constitution. Checks and balances mechanisms exist to prevent one level of government from becoming too powerful, often through the judicial system interpreting the Constitution. Constitutional framework. The division of power between levels of government is clearly defined within a written constitution. In the United States, the federal government handles matters like national defense, foreign policy, and currency, while state governments manage issues like education, healthcare, and local laws. The Constitution establishes a federal democratic republic form of government. That is, we have an indivisible union of 50 sovereign states. It is a democracy because people govern themselves. It is representative because people choose elected officials by free and secret ballot. What is General Order 100, the Libra Code? General Order 100, also known as the Libra Code, was a military law that governed the conduct of soldiers during the American Civil War. The Libra Code was intended to protect the rights of civilians and soldiers, and to establish how prisoners of war should be treated. The Libra Code prohibited the killing of prisoners of war, but allowed for their exchange. It also established equal prisoner of war exchanges between the Union and Confederate armies, regardless of race. The Libra Code is still referenced in the Department of Defense Law of War Manual. Marquette University law professor Paul Finkelman talked about Abraham Lincoln's General Order No. 100, which was commonly known as the Libra Code. This updated codification of the laws of war governed soldier conduct, prisoner of war treatment, and civilian rights. Grants of contractual authority. All plainly stated grants of contractual authority evident in the Constitution for the United States of America remain in place, subject to good faith performance of the accompanying obligations and treaties. Mr. Obama is the president of a governmental services corporation under contract to provide stipulated services to the organic states and is on their payroll. He otherwise acts as a foreign dignitary representing the United States of America, minor. What is contractual authority? Contract authority is a statutory authority that allows agencies to enter into obligations before receiving the cash to pay for them. It's a type of budget authority that's distinct from others because it doesn't provide the funds needed to meet the obligations. Instead, the obligations are paid for later through an appropriation or offsetting collection. Congress usually grants contract authority in an authorizing statute. It's often associated with transportation programs, such as the Highway Trust Fund, as well as mass transit and airport programs. Contract authority was created in 1922 in response to the centralized federal budget process. It allows the government to sign contracts and incur legal liability before an appropriation is made. What is a governmental services corporation? A governmental services corporation is a government-owned company that provides a service to the public and is intended to generate revenue to fund its operations. They are established by Congress to perform a public purpose and are similar to private corporations in that they are independent and operate separately from other government entities. It is owned or controlled by the government, operates independently, with a charter that gives it operational freedom, provides a market-oriented service to the public, and generates revenues to fund its operations. United States Postal Service, Amtrak. The federal government has been using the government corporation model for over a century. Congress often introduces bills to establish new government corporations. What is a foreign dignitary? A foreign dignitary is a person of high rank or importance from another country, such as a head of state, member of royalty, or high-ranking government official. In the United States, the Diplomatic Security Service, DSS, is responsible for protecting foreign dignitaries who visit the country. Major dignitaries from other countries might get to meet the president when they visit the U.S. If you see the word dignity in dignitary, it gives you a clue to its meaning. When we treat people with dignity, we're treating them with respect. A dignitary is a person with an important position in society. Foreign dignitaries can include foreign ministers, current or former heads of state or government, members of the British royal family, the Secretary Generals of the United Nations and NATO, and His Holiness the Dalai Lama of Tibet. High-ranking members of royalty, religious or spiritual leaders such as the Pope or the Dalai Lama, high-ranking representatives of foreign governments. Special protocol is often required when interacting with foreign dignitaries, such as when extending invitations to events. The protection of foreign dignitaries is also covered by 18 U.S. Code Section 112, which prohibits a number of offenses, including assaulting, striking, wounding, imprisoning, or offering violence to a foreign official or official guest, violent attacks on official premises, private accommodations, or means of transport, intimidating, coercing, threatening, or harassing a foreign official or an official guest. In neither of these capacities is he allowed any granted authority to impose upon American state citizens, endanger American state property, or command mercenary forces on American state soil, however veiled as federal civilian service agencies. We require the Joint Chiefs of Staff and General Ham to commence measures to disarm federal civilian agency personnel and to seize control of the vast stockpiles of arms which have been improperly amassed by the Department of Homeland Security, FEMA, and other agencies employed by the United States. The only federal agency allow free egress on the land of the American states is the U.S. Marshal Service, and then only when their personnel are engaged in their duty to protect the U.S. mail and sworn to act as constitutional officers. What is Federal Civilian Agency? A federal civilian agency is a government organization that is part of the United States federal government's departments and agencies, and is staffed by non-elected, non-military employees. Federal agencies are created for specific purposes such as managing resources, overseeing financial aspects of industries, or addressing national security issues. In law, agency is a legal relationship between two parties where one party, the agent, acts on behalf of the other party, the principal. The agent has the authority to act on behalf of the principal and consents to do so. The principal controls the agent. An employer and employee, a shop manager and the owner of the shop, or a lawyer and their client. The laws that govern the relationship between the agent and the principal, including the agent's duties and the liabilities of each party. A formal agency agreement is called a power of attorney, where the agent is called the attorney in fact. The agent's agreements are binding on the principal if they were within the agent's authority, or if a third party reasonably perceived them to be. An employer is usually not liable for the actions of an independent contractor unless the contractor was given the authority to act on the employer's behalf. Agency law is a subset of business, tort, and contract law. What is a constitutional officer? A constitutional officer is a government official who holds a public office created by a constitution rather than by a law. They are responsible for specific duties and have a fixed term of office. Constitutional officers are accountable to the people they serve and must uphold the laws of their government. Examples of constitutional officers include state constitutional officers. These officers lead the state governments of the United States. The number and powers of these officers varies by state. National constitutional officers. In the American Legion, the National Executive Committee appoints 6 national constitutional officers annually. These officers include the adjutant, treasurer, judge advocate, historian, chaplain, and sergeant-at-arms. Constitutional officers in labor organizations. A constitutional officer in a labor organization is a person who holds a position identified as an officer by the organization's constitution and bylaws. All other federal agency personnel are limited to unarmed service until further notice. We direct the Joint Chiefs of Staff to communicate these first 2 general civil orders directly to Mr. Obama, the members of the U.S. Congress, the administrators of all federal agencies, the members of the Supreme Court, and those acting as governors to compel their rapid understanding and cooperation. What is a general civil orders? A general civil order is a court order that applies to the high court and county courts and is issued by a judge. General civil orders are valid for 3 years but can be renewed for another 3 years. If a person ignores a general civil order, they may be held in contempt of court and face a prison sentence. Civil cases are disputes between 2 or more parties where the plaintiff claims the defendant violated a civil law and caused injury or damage. The plaintiff may seek monetary damages or ask the court to order the defendant to stop the harmful conduct. Other types of civil papers include injunctions, a court order that prohibits someone from doing a specific act; subpoenas, a process to compel a witness to appear and testify; summons, a writ that requires a person to appear in court and answer a complaint. What is cooperation? Cooperation in law can refer to a number of things, including cooperation in criminal law. A defendant may cooperate with the government in exchange for a reduced sentence. This is known as a cooperation agreement, and it can involve providing information, going undercover, or testifying in court. The defendant's cooperation must be substantial, and the prosecutor has discretion to decide whether to ask for a sentence reduction. A voluntary process that uses interest-based negotiation techniques. Cooperative lawyers can continue to represent their clients in adversarial proceedings if the dispute isn't resolved. A principle of mutual recognition of judicial decisions and judgments. Businesses that are organized under state laws and governed by a charter and bylaws. Cooperatives can be consumer co-ops, rural utility co-ops, credit unions, housing co-ops, agricultural co-ops, or worker co-ops. Cooperation means participation or assistance for the mutual benefit of both parties or the sole benefit of one party. Any expense or damage incurred by these organic states or any American state citizen as a result of actions undertaken by any federal agency personnel acting as armed mercenaries on American state soil will be understood as the result of violent crime committed against the peaceful inhabitants of the land, and will incur immediate judgment liquidating the assets of the International Monetary Fund, IMF, and the Federal Reserve in payment of the stipulated reparations. Such crimes shall also be considered contract default, increasing the public debt subject to bounty. Any and all corporate officers of the United States or any successor organizations inheriting federal service contracts who support, condone, or promote such crimes against the American states or against American state citizens shall be subject to arrest and prosecution for commercial and violent crimes. What is a corporate officers? A corporate officer is an employee who manages a corporation's day-to-day operations and is appointed by the board of directors. The board of directors makes the decisions, and the officers are responsible for carrying them out. The exact roles and number of corporate officers varies by state law and the company's articles of incorporation. However, some common corporate officers include: President usually makes decisions about corporate policy and operations. Vice President takes over the President's duties when they are absent and may also be responsible for running part of the corporation. Secretary keeps the corporation's books and records, including meeting records and the stock record book. Treasurer, responsible for the corporation's money, taxes, and financial reports. Corporate officers have several duties, including executing board plans. Officers are responsible for carrying out the board of directors' plans. Proposing strategies. Officers may also propose objectives and strategies for the corporation. Signing documents. Officers are usually authorized to sign and deliver contracts and other documents on behalf of the corporation. Overseeing risk mitigation. Officers are responsible for adhering to financial compliance and supervising areas like IT security. All foreign officials operating as elected or appointed officials of the United States of America, minor, who support, condone, or promote such crimes against the American states or against American state citizens shall be subject to arrest, confiscation of their assets, and deportation to Puerto Rico, Guam, or such other states as may be willing to receive them. Such foreign officials include members of the American and British Bar Associations who were licensed to act as privateers against the interests of the American states and the American state citizens from 1845 to 2013 in flagrant breach of trust. All such licenses are now extinguished. What are licenses in law? In law, a license is a legal right to do something that would otherwise be prohibited. It can also refer to the physical document that grants permission, such as a driver's license or a permit. Here are some examples of licenses: governmental licenses, permission to perform a specific act, such as getting married, driving a car, or operating machinery. Intellectual property licenses, permission to use intellectual property, such as a patent, trademark, or copyright, for a specific purpose. Real property licenses, permission to use all or part of a property for a specific purpose, such as putting on a concert. Contractual licenses, permission to enter or use property in exchange for something, such as purchasing a movie ticket. The term license can also be used as a verb to mean granting permission. When entering into a licensing agreement, it's important to consult with an attorney to understand the complexities of intellectual property law. Generally, a license is permission granted by a qualified authority permitting a licensee to do something that would otherwise be prohibited. License may also refer to a physical document granting such permission, sometimes referred to as a permit.